session. The Honorable Judge Jeff Prograth presiding.
Thank you very much. Please be seated. Make yourselves comfortable. Welcome.
Welcome, welcome. Good afternoon, everybody. Let me call it the case State of Florida versus John Goodman, and let me note for the record Mr. Goodman's present. Good afternoon, and he's here with his attorneys. And state's represented by Ms. Roberts and Ms. Collins. And I thought we would proceed with interviewing Mr. DeMartin first, see what that yields, and go from there. Anybody have a plan different than that? Sound good?
I'd like to address the court prior to the DeMartin hearing.
Let's go ahead. You're on. You may proceed.
Thank you. We have some exhibits that we're going to submit to the court that I think bear upon this particular thing, but I wanted to start off with the following. How serious is this matter dealing with Mr. DeMartin? This is not just about a 68-year-old man out on some type of a lark while he's in jury service. What happened here goes directly to the heart of the fairness of a trial. First of all, we have a juror who was writing a book during the course of the trial and managed to publish it even before sentencing, which is probably a first in jurisprudence as far as I know. But his experiment went directly to the heart of our defense, and it violates a number of my client's constitutional rights. It violates his right of confrontation, his right of cross-examination, his right to rebut the experiment, his right to comment on it in closing argument, because his lawyer has a right to comment on all the evidence. And of course, nobody, not the court, not the state, nor the defense, knew about this. The court, we were unable to submit a curative instruction that the court could have given to the jury regarding how to use this. And of course, most importantly, he lost his right, his Sixth Amendment right to counsel, because there was no way for us to reply to this or to ameliorate it or to mitigate it in any way. So what he did undermined all those protections. And those are the rules that were created to give us a fair trial. And when we undermine those rights, this is a very serious matter. And the question comes up is, how material is this? Because you have those cases where somebody had a magazine in the jury room, or someone looked up the definition of a word, or things like that. In this case, this so-called experiment went right to the heart of the case, because the state presented an expert witness, Tate Yateman, who said having 3 drinks between 11:20 and 12:30 would make a person with a blood alcohol level of approximately 0.04. And if they had a full meal, which Mr. Goodman did, it would be under a 0.04. The court then instructed the jury that if a person has a blood alcohol content of less than 0.05, you are to presume that he is not impaired. So this experiment, this recreation, it's not really an experiment, it's a recreation of our defense to determine whether it was valid or not. And his recreation directly contradicted your jury instruction and our defense. And we did not call our toxicologist. Instead, we relied upon the testimony of Mr. Yateman. And I argued that extensively in the final argument, at the time not knowing about this recreation that had been done by Mr. DeMartin. So this thing is very serious, because if the state or the defense had sought to recreate the crime in some way, this court would apply pretty strict rules and controls over whether or not it would be admissible in evidence. And both sides would have an opportunity to look at it, to examine it, and then, of course, rebut it or do whatever else is to be done. You look at those cases dealing with video reenactments. The courts and the appellate courts are very strict upon that, and we missed that in this particular case. So I want to give the court certain exhibits. First of all, we have put together boards which have the relevant sections of the book and the interviews that were done by Mr. DeMartin. And first, I have these marked. I would like to submit them as exhibits to the court before we do that.
1 through 6.
Okay, yeah, we'll get to that. First is Defendant's Exhibit 8, which is the book.
Judge, they were provided as exhibits in one of the motions for new trial or
Exhibit 7, which are the interviews, tape of, or CD of the interviews of Mr. DeMartin, and Exhibits 9, 10, and 12, 9, 10, 11, and 12, which are transcripts of the excerpts of his interviews that occurred with the press subsequent to the publication of the book. And if I could, I have blown up the most important one so the court will be aware of it. First of all, in his book, he tells what the purpose of what he was doing. And this is the purpose. This is what he was going to test. He wanted to see if our defense had any legitimacy. If he had 3 or 4 drinks, how drunk would he be? And I decided to see. So there's a statement right there of what he was trying to do. This one is, and I'd move these, what are the exhibit numbers, 1 through 6?
Sequentially 1 through 6.
We move into evidence on this also, 1 through 6, Your Honor, for Your Honor's assistance. This is the actual test of what he did, having 3 drinks at 9, 9:30, and 10, and then went out and to determine what he would be like. And, of course, he says that he was confused. Then the next one, which is Exhibit 3, he gives us the decision that he made. Said when he woke up the next morning, he said even if a person is not drunk, 3 or 4 drinks would make it impossible to operate a vehicle. That's the part that is directly in conflict with the testimony in this case. And he says, right, thank you. The question in my mind the night before was answered to me. That's how he made his decision. And then he confirms this decision with his discussion of what went on in the jury deliberations. And he said the jury felt he was not fit to drive. And then he emphasizes this. As the emphasis is in the original, we do not add this. I surely decided that the night before. I don't know how you could get more adamant than that. And then he confirmed his writings with interviews that were done on May 4th, which are in the CDs, and he told the reporter that he wanted to test it himself, how we would act after 3 drinks. And he said, and I think this is critical, I had to make a decision on this man's life the next day here. I mean, I don't know it could be any clearer about what he was using to make a decision. And then finally, he says that the court never instructed him on this, and of course we know that that is not true. But the most important part here is the end. He said, I had 3 drinks the night before to see how I would react if I was him. He was doing this as a recreation of what Mr. Goodman was doing that night. He can't get any clearer than that. I had 3 drinks the night before to see how I would react if I was him. So we would ask the court, when it questions Mr. DeMartin, that the court just ask if he actually wrote those words and made those statements to the press and whether or not they are true. We have submitted a memo to the court with a Florida Supreme Court case and 2 4th DCA cases saying the court, and the court has recognized this already, you can't ask anything that would adhere in the verdict, so you can't ask him how much this affected him or whether it affected him or how he came to his verdict. But I think the court has to establish, in my opinion, that what he said is true, that he did this test, this recreation, and I think that ends the inquiry.
A couple of points, and I'm just curious about your point of view on it. First, how do you square all of that with Mr. DeMartin's previous statement at the last interview where he said at the beginning of the deliberations he was prepared to vote not guilty? He was going in with, I'm going to vote him not guilty. How do you reconcile your hypothesis that, oh, this was the death knell to John Goodman and his rights, yet he was thinking not guilty at the beginning of the deliberation process, and that it was hearing the interview, the 911 call that tipped it for him.
Actually, what he says about the 911 call is not that it tipped it for him regarding the drinking. It had to do with his responsibility of not having reported it and from leaving the scene. So when he testified, what he's explaining, that's why he thinks he's guilty of leaving the scene, because he didn't take responsibility, didn't call 911, called his girlfriend, called his employee, and what have you. So that, I believe that relates to that. But it makes no difference, any of that, because all that in here is in the verdict. What it has is whether or not he did a test or a recreation that he says that in his own words, he surely decided that the night before. So who knows exactly when it hit his mind that all this comes together. All it has to do is to be done. We do not have to prove it affected him. All you have to prove is that this was done outside of court, outside of the rules, outside of the parties, and it was material to an issue in the case. If it was immaterial to the case, if drinking had nothing to do with the case, then the court could say it's not material and I can ignore it.
Well, and that goes to my other point I wanted to ask you to comment on, and that was your theory didn't seem to be Mr. Goodman isn't too drunk to drive. Your hypothesis, your theory was he did all the drinking, or he did the drinking after the accident, and not your argument and your line of questioning with the witnesses established that, yeah, he had 1, 2, maybe 3 drinks before he drove, but because of the time frame involved, he certainly wouldn't have been impaired at all, and that the reason he had the blood alcohol level of in excess of 0.20 was because he drank after the accident. How does that, I mean, isn't this all for nothing if we follow your theory of the case?
I'm glad Your Honor asked me that, because I think that's a critical issue. Mr. Goodman had 1 drink, I think the evidence would show, at the White Horse Tavern. He then had 3 drinks at the Players Club. So he had either 3 or 4 drinks. That's why he does the experiment of the 3 or 4. Our position is, by having 3 drinks at the Players Club and 1 drink at the White Horse, he was not impaired at 1 a.m. when the accident occurred. He was impaired at 4 a.m. when the blood test was done, because he had drank between 2 a.m. and 3 a.m. when he was at the barn. So that part of the case explains his blood alcohol level at 4 a.m. in the morning. But the critical part of our defense was having those 3 drinks, because what Yateman said is the 1 drink at the White Horse no longer had any effect on him, and he had the meal there. And he had 3 drinks at the Players Club. Accepting he had 3 drinks at the Players Club, Yateman said he would be a 0.04 or below. That's what happens at the accident. That is the crime, whether or not he was over a 0.08 at 1 a.m. in the morning. So I'm glad you asked me that question, because that goes directly to our defense, not to the state's indictment, but it goes to our defense. So his recreation was used to debunk our defense.
Okay. Thank you very much. Ms. Collins, any comments before we bring in Mr. DeMartin?
Yes, Your Honor. There's one thing that the defense left out for that whole presentation, and that is that if the state or the court can find that there is not prejudice, then it really doesn't matter if it was extrinsic or material. And I think it's still important, as was pointed out in the state's response, as to whether or not this even is something that's extrinsic. In terms of juror misconduct, and I think that both counsel for the defense and counsel for the state, and probably the court as well, have probably read every juror misconduct case that exists in the country. And believe it or not, there aren't that many. When you look at it as a whole on this issue, there are really only a couple dozen cases that exist in the country on this issue. So when you look at it across the board and across the states, they say that just because there's juror misconduct, and even just if it's material, it doesn't mean that it results in a new trial. It doesn't mean it results in prejudice. And it's a case-by-case basis. And there were quite a few issues that were even worse than what we saw here that were found not to be prejudicial, not to be extrinsic, and not even to be material. So I think that's going to be something that's going to have to be decided by the court after talking to Mr. DeMartin. Now, in terms of the boards, and I think it's kind of stretching it to call it a book. It's about 38 pages. It's more of a pamphlet of ramblings that was done by Mr. DeMartin and published on Amazon.com. And this is the United States of America, and there's no reason why he can't try to spin and make a buck if he's otherwise following the rules and the law of the state of Florida. But what it comes down to, it really doesn't matter what he wrote in his book, and it really doesn't matter what he told the press. He has every right to do those things. I think that both counsel for the state and counsel for the defense were on different hands, either eagerly awaiting what he was going to say to the press or cringing and waiting what he was going to say to the press. But it goes without saying he didn't do anything wrong in either writing it or in talking to the press. But what it comes down to is, what did he do on that Thursday night in between the time when they broke, and not what it had on his mind, but what did he do, and then the court's determination about whether or not there was prejudice as a result of it. Counsel's argument in terms of the self-reported number of drinks that Mr. Goodman had is just that, and the fact that he would have been under a .04 and he may not have been impaired all leaves out one glaring fact, and that is that it is uncontroverted that the defendant had hydrocodone in his system at the time. And even with a .04 or a low blood alcohol level, Tate Yateman testified that the hydrocodone would have had an impairment effect on the defendant based upon the milligram that his dosage was as prescribed by his doctor, and the time that he last took the dosage based upon what was in the medical records that were reported by the defendant after the crash. So it goes without saying that that still is not necessarily a material matter that needs to be addressed. The state's position, as we did in our response and as we continue to do, is that there was no instruction to the court that any of the jurors couldn't have said, this was a really tough day. We had closing arguments. We were sitting there for hours. It was really exhausting, and they went home and they had 2 or 3 beverages. And what if one of the jurors or Mr. DeMartin, after doing that, said, wait a minute, I just had 3 drinks in about an hour, which would have been the same drinks that Mr. Black says that Mr. Goodman had at the Players Club. Wow, I wouldn't drive a car at this point, or, you know what, I feel fine to drive a car at this point. In that situation, they wouldn't have done anything wrong. It wouldn't have been anything that would have been misconduct or a problem. The case law is real clear that it's only when they go to do something that's not within their normal life experiences, pretending a broomstick's a gun and sticking it out of a car, lighting mattress stuffing on fire. Things like that is when they're doing things outside of their normal activity, is when you're talking about extrinsic activity, looking it up from an outside source. So the state's position is that just calling it an experiment or calling it a test doesn't necessarily make it misconduct. Is it foolish and stupid, and does it look really bad? Sure, absolutely. Do we wish we didn't have this? Sure, absolutely. But what it comes down to is that the fact that he planned it and did it that way makes it a little more difficult. But if he had done it the other way and then realized that, oh my goodness, this is how he felt, or if he had done it the week before the trial happened and said, you know what, and shared it with the jurors, I did this the week before the trial happened, and there's no way I would have driven with 3 drinks in less than an hour. And because of that, because life experiences are allowed, and because there's a difference between normal life experiences and normal activities versus trying to do something outside of your normal experiences, that's where the issue lies. Mr. DeMartin never said he was a non-drinker. Mr. DeMartin said in jury selection that he does drink, that he feels that after 2 drinks, he would probably be okay to drive. That's what he said in jury selection. So he never said that he did not drink at all. So frankly, parties for both sides accepted him as being someone who did drink alcohol on occasion. What the state feels is appropriate to be asked is, did he drink alcohol on the night of, I don't remember what the Thursday night date was. The night before, I think it was the 29th, 22nd. It's 22nd, I think. Did he drink on the night of the 22nd where he had 3 drinks in the course of an hour? And did he share the results of that with the other jurors? That's really what the state thinks needs to be asked. And in terms of that, then the court needs to determine, based upon his answers, as well as any other answers that he made, and the state would ask the court to put him under oath, and the state feels that any other statements that he's made in court before all the parties and before this court can then be considered along with the abundance of evidence in this case so the court can make a determination based upon the law and the facts.
And Mr. Black, before I let you all sit down, a couple of questions. What if, to try to put a finer point on your issue, what if one of the other jurors, that night before they deliberated, 2 nights before deliberated, 3 nights, that was their normal custom. They go home, they have a couple of cocktails, before dinner. And is there anything wrong with that?
No.
Is there anything wrong with that hypothetical juror coming in during jury deliberations and saying, hey, you know what, I go out to the sports bar, I'll have a couple of beers, or I'll have a couple of drinks at the dinner table. I don't feel, that doesn't affect me, or it does affect me. Is there anything inappropriate about that kind of communication during a jury deliberation?
No, I don't think so.
What is it that makes Mr. DeMartin's behavior offensive? That his sitting there drinking, he calls it an experiment for the purposes of his book, or
no, because what he clearly did is he said he wanted to test to see how the defendant reacted that night. That's what he was doing. That's why he had a drink at 9, at 9:30, and 10. And then he went out walking around to see what his mind would be like, to determine whether or not Mr. Goodman would have been impaired and therefore could not drive. This goes directly. This is not some type of a social drinking kind of situation. This is not something that he did in his background. In fact, he said he hasn't drank since he was in college, and he's a non-drinker now. At least that's what he said in his statements to the press. So he did this deliberately to determine how Mr. Goodman reacted the night of the alleged crime. He wasn't doing it socially. He wasn't doing it to be nice. He wasn't doing it because that's what he normally does. Is there a case on point? There's one case, and I disagree with Ms. Collins' idea that there are cases that are worse. There's one juror who went home and checked the wiring in his house. Well, you could check the wiring in your house anytime you want, right? But the court said that that was an improper test of the evidence in the case because the person was testing his wiring to see if it matched the testimony in the case. What this man did is he did this test not to have some type of a social thing or what have you, but to see whether or not John Goodman was impaired when he was driving his car. You can't get any more material than that. That's the whole case.
All right, thank you very much.
There's one quick thing. I want to tell the court, in volume 15 of the uncertified transcript, on page 8, Mr. DeMartin said, well, I think I myself personally, I can have 2 drinks and I'd be fine. Some of the ladies I go out with after 1 drink, they don't know what they're doing. So I feel, and then Mr. Black said, don't give away your secrets. And Mr. DeMartin continued, but I just mentioned, I don't have a car, and if I go out with them and I see them have a drink or 2, I'm going to drive, or else they're not going to drive home. That's the way I feel. When Mr. Black asked, okay, and are you going to look at what the standard is rather than some personal code like, you've got to be impaired or over a blood alcohol level? Mr. DeMartin said, I'm going to go by the law. You're telling us that we've come here for a trial of what the law is. I think I have to follow the law. And in terms of the wiring case, I read that one as well. A juror who goes home, who doesn't normally check his wiring on a regular basis, and goes home and opens up the walls of his house, that's different. That's doing something he normally, ordinary doesn't do. That's something outside the norm. Going home and having a cocktail, according to Mr. DeMartin, is not outside the norm.
I'm glad she brought that one up because he said, I'm going to follow the law. And, of course, that's what he's supposed to do. But he didn't. He instead did this test and then violated the law.
Thank you very much. Someone's dropped off an unsigned statement here purporting to be from Lily Wilson.
Yes, I did, Your Honor.
All right.
I just got it a few minutes ago, and I gave a copy to the defense and a copy to you.
Thank you. Let's bring in Mr. DeMartin, please. Oh, and let me ask the press once again to, as an accommodation, I appreciate it if you don't. He's here because he's been summoned, so I'd appreciate it if you don't show his face in the proceedings.
Good afternoon, Mr. DeMartin.
If you'll step up to the podium, please. Good, thank you. Raise your right hand, please. Do you promise that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I so do.
Okay, thank you so very much. And for the record, please tell us your name.
Dennis DeMartin.
And Mr. DeMartin, you were one of our jurors, is that correct?
Right.
I've called you back down here to follow up on some issues that came to light since the last time I saw you. And I have to make sure that that only proper evidence was considered during the deliberations, and that Mr. Goodman gets a fair trial, and that nothing inappropriate or improper came into the jury's consideration from the outside. And the issue revolves around this drinking that you did the night before the jury deliberations, and was that an improper influence or not? First of all, let me ask, did the things you wrote about in your book, are those accurate, or see, maybe this was a fictionalized, maybe you used hyperbole, maybe you wanted to make your story more interesting than maybe the facts suggested, and so is what you wrote about accurate?
I object to that question.
What's the objection?
Well, the editorializing.
Okay, the objection's overruled.
It is correct. I didn't take the drinks to find out if he was guilty or not. I had determined he was guilty by not calling 911. I took the drinks to see if I would be functional enough to be able to handle anything like that. I found that I wasn't, and I said to myself, maybe he wasn't. So I took the drinks not to prove that he was guilty, that he was probably not rational when the accident happened. He's human and he makes errors. I'm human. I made errors, as we see.
Did you have any hydrocodone in your system at the time that you had these drinks?
I don't even know what hydrocodone is.
It's a medicine that's prescribed for pain.
No.
Okay.
The 3 drinks is what I had, and as I said, I made the mistake. I come back, so then I figured I wasn't functional. And then, as you know, I wrote you a letter later after going to a lecture on there is a law of good, and it's always functional 24 hours a day. So that's where. Go ahead.
During the deliberations, did you tell the other jurors, hey, I did this experiment?
Told that to the verified or not.
All right. Mr. Martin, thank you very much. You're excused.
That's it.
I'll have you stay in the jury room for a couple minutes. I don't think I'm going to need to recall you out here, but. State any other argument you'd like to add to that which you presented already?
Your Honor, I think that just this case is very analogous to one of the cases that the state cited, and that is the Nevada case of State versus Tanksley. It was an arson case, and the facts of that criminal arson case were that the prisoner lit the stuffing of his mattress on fire. The jury was hung with one holdout. During the break in the trial, during the deliberations, the juror went home and lit the stuffing of his mattress on fire. And the juror who went home was the holdout. And lo and behold, it lit and it went on fire and it was incendiary, just like the prosecution had said. And he came back and he said, you know what? I'm still voting not guilty. And it wasn't until later on in the deliberations that the other jurors convinced him to vote guilty, and then the verdict returned guilty. And the Nevada court said misconduct, no prejudice. And again, I think there's quite other cases that are worse than ours. Other than that, Your Honor, the state would rest on what we filed.
All right, Mr. Black, final thoughts on this issue?
Yes, Your Honor. First of all, Mr. DeMartin has now said that he did the experiment to determine whether or not Mr. Goodman was impaired at the time of the accident, and he determined that he was not a responsible person because he had 3 drinks. There are numerous cases that almost analogous to this. We cited one, Bickle versus State Farm Mutual Automobile, where a person experimented with a car. We have another one that was Jennings versus Oku, which is a 4th district case. Oh, no, it's a federal case, I'm sorry, where they experimented with a car to see if it would leave a fingerprint on the door jamb, even though people use cars every day. A case where someone goes to the tire store. There was one case that is a 3rd district case where it was improper for a juror to describe an intersection where the accident occurred, even though they didn't go there. So there are many cases that are almost exactly like this. He has now admitted that this went to the most important issue in the case, whether or not Mr. Goodman was impaired. And the case, the prison case, dealing with whether or not the prisoner was the one who set the fire, all that person did, as I recall the case, is look through a pair of binoculars to see if you could possibly see something through binoculars, like somebody throwing a rag in a room in a prison. And the court held that that was improper, even though looking through binoculars is something that people do all the time. This man has now admitted he did it in order to determine this case. And I think this is as clear as it gets, Your Honor.
Thank you very much. Ladies and gentlemen, I'm going to take about a 10-minute break. I'm going to go collect my thoughts. I'm going to take a look at some of the cases that are just cited that I haven't had a chance to look at, and then I'll come out and give you my answer, and then we'll pick up from there. So let's take about a... Yeah, the federal case, I don't have that federal case you referred to. Yeah, the Nevada case. And then the federal case, I don't recall reading that one that Mr. Black just referred to. If they were submitted, they got lost in the shuffle.
And Judge, I have a set for the court reporter, so she has it.
Thanks. Thank you.
All my cases.
Mr. Black, thank you. Thank you. All right, take a 10-minute recess.